Right, a great deal could be said about state aid and tax, but I'm going to focus today on the theme of the conference, which is business in an uncertain world, and particularly I'm going to focus on whether the Commission investigations currently underway, now pending before the court in a number of cases, whether that's escalating uncertainty or not, and if so, why that's happening. I have to, like the previous speaker, emphasize I'm speaking here entirely in a personal capacity. I'm not speaking on behalf of any government or any taxpayer client that I might be representing. That being said, I'd have to say that perhaps my slightly jaundiced view of this issue arises from the fact that I am now spending 25 to 50% of my time on issues concerning state aid and taxation, something that I never anticipated when I began in practice 30-odd years ago. So I think it's a fair question to ask at the very beginning, and that is, why is state aid, which of course didn't start as an issue related to taxation, why is state aid and the tax investigations adding to business uncertainty? After all, state aid isn't new. The state aid rules are there in the original treaties, and they go back to the Treaty of Rome in 1957. And similarly, the application of state aid to tax isn't new. Back in 1997, we had a Commission notice on the application of state aid to measures relating to direct business taxation. We had a round of Commission decisions in the early 2000s on a number of tax schemes, for example, the German Control and Coordination Centers case, but a number of other cases at the time. And we even had cases that went on to the General Court and the Court of Justice, for example, the Forum 187 case. So why, given that this isn't new, has it created particular issues of uncertainty? Is it just that tax advisors have been asleep at the wheel and have missed state aid, or that there is something special about what is going on at the moment in terms of the investigations? Well, I'd like to try to offer three explanations as to why the current investigations are having this effect of uncertainty. First explanation arises from the fact that the Commission, DG Competition, is deploying and inventing a number of entirely novel theories previously unheard of in a number of the investigations. They're inventing totally novel theories of taxation as part of the investigation. And the best example of that is something that is becoming referred to as EU ALP, European Union arm's length pricing, arm's length principle, or the Commission's ALP. And that, as a concept, first appears in the Starbucks and FIAT rulings in October 2015. And if you search for it, there is realistically no earlier evidence before that date of the existence of this phenomenon. It's a totally novel idea that has come out. To make that good, let me take you through, if I may, a paragraph from the Starbucks decision. It's recital 264, and you'll find an identical paragraph in the FIAT decision as well. And I think this shows the novelty of the approach and also explains the uncertainty caused. And I'm breaking the paragraph down into its three sentences. Paragraph begins by saying, the arm's length principle, and this is part of the analysis by the Commission, necessarily forms part of the Commission's assessment under Article 107, the state aid article, of tax measures granted to group companies independently of whether a member state has incorporated this principle into its national legal system. Well, pausing there, that of itself is somewhat surprising, because the whole element of state aid is that it involves a departure from the normal national tax system. But here the Commission is saying that they are using an analytical tool which exists as part of state aid law outside of the national tax system. It doesn't matter whether the national tax system contains rules on arm's length pricing or not. State aid requires that the taxation of a multinational respects this principle, quite apart from it being part of national tax law. That of itself is both surprising and entirely novel. But then you go on to the second sentence. EU ALP, it, is used to establish whether the taxable profits of a group company for corporate income tax purposes has been determined on the basis of a methodology that approximates market conditions. Fine, but then it says, so that that company is not treated favorably under the general corporate income tax system as compared to, this is a new concept, non-integrated companies whose taxable profit is determined by the market. So we learn from that sentence that this concept that exists outside of national tax systems is actually a non-discrimination principle. Arm's length pricing and transfer pricing under the EU comes out of non-discrimination, which purports to compare integrated, that's companies that are part of a group, with non-integrated companies, non-integrated being companies that are standalone. And there will be state aid if the taxable base of a member of a multinational group is not comparable with that of a standalone company. Well, that again is both surprising and entirely novel, because it takes transfer pricing between associated enterprises and treats it as a non-discrimination issue, ensuring that the tax liability is comparable with that of a standalone company, something that did not exist as a concept before. And then just to clarify, the third sentence then goes on to say, thus, for any avoidance of doubt, the arm's length principle that the Commission applies in its state aid assessment is not that derived from Article 9 of the OECD model, which is a non-binding instrument, but is a general principle of equal treatment in taxation, falling within the application of the state aid rules, which binds member states and for whom scope the national tax rules are not excluded. It's clear from the decision, and the Commission admits this, that EU ALP, this new invention, is not the same as the OECD ALP that has been developed through the transfer pricing guidelines for the last couple of decades. It follows that compliance with the OECD transfer pricing guidelines does not guarantee to a multinational group that any ruling or tax assessment in accordance with that will not constitute state aid. And that's very clear from the decision. This new concept of EU ALP is not necessarily the same as OECD transfer pricing. So if I summarize what we get from that one paragraph, which is the core, perhaps, of the Commission's approach, Commission has invented a totally new concept, EU ALP. It's a non-discrimination rule designed to ensure that integrated and non-integrated companies pay tax on the same basis. It's not the same as the long-standing OECD ALP, which have been elaborated in the transfer pricing guidelines. Its contents remain, quite frankly, totally vague, and will remain vague until the completion of the litigation currently underway involving the current round of Commission decisions. And that will involve several years before we come to that point. Just to pick one other little phrase out of the decisions on Fiat and Starbucks, for example, EU ALP requires that a country adopts a methodology which results in a reliable approximation of a market-based outcome, which, if you abbreviate it, produces the rather nice acrostic RAMBO. So either somebody in the Commission had no concept of abbreviations, or they had a rather weird sense of humor. Just two last comments on this novel theory. I hope I've said enough to prove my point that the Commission is using completely novel theories different from those that have previously existed. The Commission argue that this approach is supported by the decision of the European Court in Forum 187. If you examine that decision in detail, you will find that that is a completely untenable argument on behalf of the Commission. There's also, for those who are interested, a rather interesting issue, which is, if the Commission is right that ALP is a necessary requirement of state aid, then it must follow that the Commission's proposals for CCCTB, which are fundamentally contrary to an arm's length approach, would be unlawful and contrary to the treaty. And I've not seen a good answer to that. Those who are not particularly in favor of CCCTB might actually find that rather a relief. Let me turn to a second explanation, and that is that in all of the major decisions that are currently before the Commission under investigation or before the court, essentially the Commission is second-guessing views expressed by national tax administrations. This is the first time that the Commission is challenging specific rulings given by tax authorities to particular taxpayers. And in many of them, the Commission is challenging the national tax administration's interpretations and applications of their own legal rules. And the clearest example of this is the McDonald's case, on which we don't yet have a final decision of the Commission, but the essence of the Commission's investigation there is challenging the Luxembourg tax administration's own interpretation of their own provision in their own treaty between Luxembourg and the US. And fundamentally, the Commission, if they follow their opening decision, are saying that the Luxembourg tax authorities do not know what their own tax treaties mean, and the Commission does. And that's not the only example. In a number of the cases that are now before the courts, the Commission is challenging transfer pricing reports that have been prepared by leading firms with known expertise in transfer pricing, which have been accepted by tax authorities and accepted to be a correct application of the transfer pricing guidelines. But so far as I'm aware, in none of those cases has the Commission provided any evidence of an equivalent expertise to dispute those reports. So we have reports produced by experts, accepted by experts, where the Commission, without producing contrary evidence, disagrees with the outcome, very often based upon particular sentences lifted out of OECD publications. And what's creating a particular issue here is that the European courts, the General Court and ultimately the Court of Justice, is going to be asked to determine extremely technical issues relating often to transfer pricing without any evidence backing up the Commission's position, which is a very unusual situation to be facing with regard to transfer pricing matters. Quickly, the third explanation concerns the target matter of the Commission's investigations. The Commission is currently targeting tax rulings, and you might here like to contrast what I'm saying about state aid with what Georgia mentioned earlier about the number of companies that expressed a wish to obtain pre-clarification by having reliable rulings. There is no doubt that tax rulings might be used to grant unlawful state aid, but they provide a necessary measure of certainty, which is essential in a number of areas and in a number of countries, for example, in the field of APAs or the application of anti-avoidance measures. Essentially, by examining these rulings in the way that it has done, the Commission has undermined reliance on rulings, and there's anecdotal evidence that this may even be deterring businesses from seeking rulings within European countries. Now, one of the issues here is the procedural approach that the Commission has taken, because the Commission has proceeded by calling in large numbers of rulings and then opening investigations into what the Commission determines are, in the words of some of the Commission officials, outliers. But there is no guidance given as to what constitutes an outlier. If you obtain a ruling and it is examined by the Commission, you do not know whether it's likely to be regarded as an outlier or not. Perhaps what the Commission should have done is to proceed by first developing guidelines on rulings, identifying those that are acceptable from a state aid perspective, and then choosing rulings that are outside those guidelines for investigation, rather than perhaps working the other way round. Well, with those explanations, let me come to my last couple of points, and that is, why has the Commission done this? Given the almost certain uncertainty that was going to result, why has the Commission acted in this way and targeted these individual rulings? Well, I think it's very hard to avoid the conclusion that state aid is being used to advance a political agenda with regards to national tax systems, both inside and outside the EU. And so far as outside the EU is concerned, I leave it to you to identify the possible country concerned. It's also hard to avoid the conclusion that state aid is being quite deliberately misused outside of its proper role for purposes that have realistically nothing to do with state aid law. And I would say that's perhaps not the only example at the moment of the misuse of rules, procedures, or projects by governments and international organizations for purposes different from those that they are publicly stated. So, concluding comments, the uncertainty created by these state aid investigations will not go away. It will remain at least until the courts, and that probably means the Court of Justice eventually, have decided the current batch of cases. And even if the courts throw out the Commission's decisions, it's unlikely to restore certainty for some time. Once that process is completed, and this is an entirely personal view, I think there is a very good justification at that time for there to be a full inquiry into the process within the Commission at the level of officials and commissioners, which led to this position of creating this uncertainty. Thank you very much indeed.